The House Armed Services Committee hearing room buzzed with the usual pre-session energy. Camera crews adjusted their equipment. Staffers shuffled papers and reporters checked their phones one last time. It was supposed to be another routine oversight hearing on defense spending, the kind that typically drew minimal public attention beyond policy wonks and military contractors. But in the second row of the Democratic side sat Representative Maria Gonzalez from California, quietly reviewing a thick manila folder that would soon turn this mundane Tuesday morning into the most explosive congressional moment of the year. What happened in the next 18 minutes would rack up 47 million views across social media platforms, spawn countless reaction videos, and permanently alter the trajectory of two political careers. Before we dive into exactly how a second-term congresswoman from San Diego completely dismantled one of the most influential voices on military policy, make sure you hit that subscribe button and ring the notification bell. Because what you're about to witness isn't just another political confrontation. It's a masterclass in preparation meeting opportunity, and if you're watching from anywhere in America, drop your state in the comments below. Let's see who's tuning in for this incredible showdown. This wasn't supposed to happen. Defense Subcommittee Chairman Robert Hawkins had scheduled this hearing to discuss budget allocations for overseas military installations. His staff had prepared talking points about fiscal responsibility and national security priorities. Conservative media had already booked him for evening appearances to discuss his expected critique of Democratic spending proposals. Everything was proceeding according to the well-rehearsed script that had played out in countless similar hearings over the past decade. But Chairman Hawkins had made one critical miscalculation. He had completely underestimated Maria Gonzalez. The morning had started exactly like any other high-profile committee hearing. The gallery filled with the usual mix of defense contractors, policy analysts, and journalists covering the Pentagon beat. Hawkins, a veteran of 12 years in Congress, settled into his chairman's seat with the confidence of someone who had dominated these proceedings for years. His reputation as a military policy expert was built on aggressive questioning, detailed knowledge of defense contracts, and an ability to cite complex procurement regulations from memory. As members filed into their seats at 9:30, 15 minutes before the scheduled start, something was noticeably different about Representative Gonzalez. While her colleagues chatted with staff or scrolled through morning briefings, she sat in focused silence, methodically organizing documents in her folder. She had arrived at her office before dawn, spending the final hours reviewing defense appropriations data that her team had been compiling for weeks. "You absolutely certain about this approach?" her chief of staff had asked at 6:15 that morning, reviewing the aggressive line of questioning she had prepared. "Hawkins thinks because I'm newer to the committee, because I don't come from a military family, that I don't understand defense policy," Gonzalez had replied, never looking up from her notes. "He's about to discover how wrong he can be. To understand the magnitude of what was about to unfold, you need to understand these two individuals and why this confrontation would matter far beyond the confines of a single committee hearing." Robert Hawkins had been in Congress since 2011, a former Navy officer who had built his entire political brand around military expertise. When Republicans needed someone to defend defense spending or challenge Pentagon critics, they turned to Hawkins. His rapid-fire questioning style during hearings, his encyclopedic recall of military terminology, and his willingness to aggressively challenge witnesses had made him a favorite on conservative news networks. At 58 years old, with 13 years of congressional experience, Hawkins had never lost a major policy debate in committee. His YouTube clips regularly garnered hundreds of thousands of views. His fundraising appeals based on his hearing performances consistently brought in millions for Republican candidates nationwide. He was, in many respects, untouchable within his sphere of influence. Hawkins had also positioned himself as the definitive congressional authority on military procurement and defense contracts. Despite having served only 4 years as a junior naval officer before leaving active duty, he spoke with absolute certainty about complex weapons systems, international defense agreements, and military logistics. Most witnesses and fellow committee members didn't challenge his assertions because they assumed his military background and committee seniority meant he must know what he was talking about. Maria Gonzalez represented everything Hawkins wasn't. At 42 years old, she was serving only her second term in Congress, having been elected in 2022. Before coming to Washington, she had spent 15 years as a federal contracts attorney, specializing in defense procurement law. Unlike Hawkins, she hadn't served in the military, but she had spent her entire career navigating the legal complexities of how the military actually acquired its equipment and services. But in Washington, she was still considered new. She didn't have Hawkins' seniority or his media profile. She didn't command the same respect from defense industry lobbyists or generate the same fundraising numbers. What she did have was something Hawkins had perhaps forgotten existed in the halls of Congress: actual expertise in the subject matter they were supposedly debating. Gonzalez had graduated from Stanford and earned her law degree from Georgetown, but more importantly, she had spent years in federal courtrooms arguing cases involving defense contracts worth billions of dollars. She knew the difference between political posturing and legal reality when it came to military spending. She understood procurement regulations not from briefing books, but from having to interpret and apply them in high-stakes litigation. For months, she had been quietly observing Hawkins during committee proceedings, taking careful notes every time he misstated a regulation, mischaracterized a contract provision, or simply invented procurement principles that sounded authoritative but didn't actually exist in federal law. He's been getting away with it because everyone assumes someone with his background and position must know what he's talking about, she had told her legal counsel 2 weeks before the hearing. But assumptions aren't facts, and I've been checking his facts. They don't add up. The stakes for this particular hearing were enormous. Hawkins had called it to challenge the Biden administration's defense spending priorities, specifically targeting what he claimed were illegal contract modifications and improper procurement procedures. He wanted to paint the Pentagon as wasteful and the administration as fiscally irresponsible. It was red meat for his political base and potentially devastating for Democrats if his charges gained traction. But Gonzalez had done something few members of Congress ever bothered to do. She had actually read the contracts Hawkins was criticizing. She had reviewed the procurement regulations he claimed were being violated. She had consulted with defense attorneys, former Pentagon officials, and procurement specialists. What she discovered was shocking in its implications. Hawkins had been fundamentally wrong about basic procurement law. Not just wrong in his interpretation or policy preferences, but factually incorrect about what the regulations actually required. He had been citing contract provisions that didn't exist, invoking procurement rules that had been superseded years earlier, and making claims about military spending that were contradicted by the Pentagon's own financial reports. The hearing room itself seemed to embody the power dynamics at play. Hawkins sat at the center of the elevated committee dais, his nameplate gleaming under the television lights, surrounded by the formal trappings of congressional authority. Gonzalez sat several seats to his left, her position reflecting her junior status on the committee. The physical arrangement seemed to emphasize who held the real power in this room, but physical positioning wouldn't matter for what was about to happen, because Gonzalez had brought something Hawkins wasn't expecting. She had brought receipts, actual printed copies of the defense contracts he had been misrepresenting, screenshots of his television appearances where he had made false claims about procurement law, transcripts of previous hearing statements that contradicted established Pentagon procedures. She had even brought a copy of the Federal Acquisition Regulation, the definitive guide to government contracting, with dozens of sticky notes marking the sections Hawkins had gotten wrong. Her folder contained not just evidence of his errors, but documentation of how those errors had been repeated across multiple media appearances and official statements. The gallery was packed with defense industry representatives who had come expecting another Hawkins performance. Conservative media outlets had positioned their cameras to capture what they assumed would be Hawkins delivering another devastating critique of Democratic defense policies. Liberal outlets were there too, hoping to catch a gaffe or find material to criticize Republican positions. None of them expected what was actually about to happen. None of them were prepared for the moment when meticulous preparation would meet confident ignorance, and when 18 minutes of questioning would expose years of unchallenged misinformation. At exactly 10 o'clock, Chairman Hawkins called the hearing to order. He was wearing his standard committee attire, navy blue suit with an American flag pin, the same outfit he wore whenever he planned to make headlines. The confidence radiated from every gesture as he adjusted his microphone and surveyed the room like a general preparing for battle. This was his domain, his expertise, his moment to shine. "Ladies and gentlemen," Hawkins began, his voice carrying the authoritative tone that had made him a conservative media darling. "We are gathered here today to address one of the most critical issues facing our national defense: the systematic mismanagement and illegal manipulation of defense contracts under this administration. What we have witnessed over the past 2 years represents an unprecedented assault on fiscal responsibility and military readiness." He continued for 12 minutes, delivering what sounded like an expertly crafted indictment of Pentagon procurement practices. Hawkins spoke without notes, rattling off contract numbers, citing specific sections of procurement law, referencing complex weapons systems acquisitions. To most observers, it was an impressive display of military and legal knowledge. He mentioned multi-billion-dollar programs by their official designations, quoted what appeared to be precise regulatory language, and painted a picture of an administration running roughshod over established defense spending protocols. But Maria Gonzalez wasn't impressed. She was taking notes, rapid, precise notes, because nearly everything Hawkins was saying contained significant factual errors. Not just political disagreements or policy differences, but demonstrable mistakes about contract law, procurement regulations, and basic Pentagon procedures. He was citing contract provisions that had been amended years ago, referencing acquisition programs that didn't exist in the form he described, and inventing regulatory requirements that simply weren't found anywhere in federal law. When Hawkins finished his opening statement, he looked satisfied, almost smug. He had delivered his message, established the narrative framework, and created the sound bites that would dominate conservative talk shows for the next news cycle. The familiar script was playing out exactly as it had in dozens of previous hearings. I now recognize the distinguished ranking member for his opening statement, Hawkins announced, following standard committee protocol. The ranking member delivered a predictable defense of the administration's defense policies, pushing back against Hawkins' characterizations. It was competent but unremarkable, the same partisan dance that played out in every similar proceeding. Then came time for member questioning. Each committee member would receive 5 minutes to question the witnesses, a Pentagon procurement official, and 2 defense industry representatives. This was typically where Hawkins excelled, using his time to create memorable exchanges that would generate viral clips and reinforce his reputation as a defense policy heavyweight. The first several rounds proceeded as expected. Republican members attacked the administration's spending priorities while Democrats defended them. The witnesses, experienced in congressional theater, provided careful, measured responses that avoided major confrontations. The hearing was following its predictable trajectory toward another forgettable policy debate. Then it was Maria Gonzalez's turn. "Thank you, Mr. Chairman," Gonzalez began, her voice steady and professional. She carefully adjusted her microphone and opened her manila folder with deliberate precision. "Before I direct questions to our witnesses, I need to address several statements made during today's proceedings that concern me greatly from a legal standpoint." Hawkins looked up from his papers with mild annoyance, clearly expecting her to focus on the witnesses rather than committee discourse. "The gentlelady from California has 5 minutes for questioning the witnesses," he interjected, attempting to redirect the proceedings. "I appreciate the chairman's guidance," Gonzalez replied smoothly, "but I believe it's essential that this committee operates from a foundation of accurate legal information, particularly when we're discussing billions in taxpayer dollars. Mr. Chairman, in your opening statement, you referenced the Competition in Contracting Act violations in the F-35 program modifications. Could you specify which section of CICA you believe was violated?" The room temperature seemed to drop several degrees. This wasn't how hearings typically unfolded. Committee members rarely challenged the chairman directly, especially not on technical legal matters. Hawkins' staff began whispering urgently in his ear, but he waved them off with visible irritation. "The gentlelady's time is designated for witness questioning, not interrogating the chair," Hawkins responded, his tone taking on a sharp edge that regular committee watchers recognized as a warning sign. "I'm establishing foundation for my questions, Mr. Chairman, as any attorney would do in a legal proceeding," Gonzalez responded calmly. "The Competition in Contracting Act requires full and open competition for federal contracts. You stated that specific CICA provisions were violated in F-35 modifications. Which provisions specifically?" A moment of uncomfortable silence filled the hearing room. Hawkins' legal counsel was frantically sliding papers across the table, but Hawkins pushed them aside, his jaw tightening visibly. The entire chamber seemed to hold its collective breath as cameras focused on his increasingly uncomfortable expression. "Section 2304 requires competitive procedures," Hawkins finally answered, his voice betraying less confidence than usual. "That's a correct citation, but an incomplete answer," Gonzalez replied, pulling a document from her folder. "Section 2304 of Title 10 does indeed establish competitive procedures, but it also includes 7 specific exceptions for sole source contracting." Exception number 2 explicitly covers follow-on contracts for complex weapon systems when changing contractors would create substantial duplication of cost. The F-35 modifications you criticized fall directly under this established exception, Mr. Chairman. The atmosphere in the room shifted dramatically. Reporters began typing furiously on their devices, sensing that something significant was developing. This was no longer routine partisan theater. Democratic committee members were leaning forward with interest while Republicans appeared increasingly uncomfortable. Furthermore, Gonzalez continued, not giving Hawkins time to formulate a response. You stated that these contract modifications violated the Federal Acquisition Regulation Part 43. Could you tell the committee which specific section of FR 43 prohibits the modifications you described? Hawkins' face was beginning to redden, the same color that appeared during his most aggressive questioning sessions. But now he was on the receiving end. His knuckles whitened as he gripped his microphone, clearly struggling with the reversal of roles. The gentle lady is engaging in law school examination tactics rather than addressing the serious oversight issues we're here to discuss. Hawkins protested, attempting to regain control of the narrative. On the contrary, Mr. Chairman, I'm addressing the most serious oversight issue in this room, which is the accuracy of the legal claims being made by the committee leadership. Gonzalez shot back with surgical precision. FAR Part 43 governs contract modifications. But you've fundamentally mischaracterized what it requires. Section 43.103 specifically authorizes bilateral modifications when both parties agree to contract changes. The modifications you've criticized were all bilateral, properly documented, and fell within the contracting officer's authority. She produced another document from her folder, sliding it toward the witness table where cameras could capture it clearly. This is the actual contract modification you referenced in your Fox News appearance last month. Would you like to point out where FAR 43 was violated? Because I've had 3 defense procurement attorneys review it, and they can't find any regulatory violations whatsoever. The hearing room was now in complete chaos. Republican staffers were running between seats, presumably trying to provide Hawkins with defensive talking points. Democratic members were struggling to hide their amazement at what they were witnessing. The defense industry representatives at the witness table were watching the exchange with barely concealed fascination, having never seen a committee chairman so thoroughly challenged on his supposed area of expertise. Let's discuss your claims about the Defense Federal Acquisition Regulation Supplement, Gonzalez continued, clearly just getting started. You stated that DFARS 225.7002 requires specific country of origin certifications that were allegedly waived improperly. Mr. Chairman, could you tell this committee what DFARS 225.7002 actually governs? Hawkins' expression had transformed from confident authority to barely contained panic. Beads of perspiration were forming on his forehead as he realized the trap that was closing around him. His legal team was frantically shuffling through binders, but their whispered consultations were clearly not providing the ammunition he desperately needed. The Defense Federal Acquisition Regulation Supplement covers various procurement requirements, Hawkins replied weakly, his voice lacking the commanding tone that had opened the hearing just an hour earlier. That's remarkably vague for someone who cited a specific section, Gonzalez observed, her tone remaining professionally courteous while delivering devastating precision. DFARS 225.7002 actually governs the acquisition of specialty metals, Mr. Chairman. It has absolutely nothing to do with country of origin certifications for the programs you mentioned. You've confused it with DFARS 225.872, which covers different requirements entirely. She pulled out her phone and held it up so the cameras could see the screen clearly. Here's a tweet you posted 3 days ago stating, and I quote, DFARS 225.7002 violations prove this administration ignores critical supply chain security. Mr. Chairman, how can there be violations of a regulation that doesn't govern what you claim it governs? The murmur that rippled through the gallery was audible even over the air conditioning system. Conservative media representatives were frantically texting their producers, trying to figure out how to spin what was rapidly becoming an unmitigated disaster for their preferred narrative. Liberal outlets were barely restraining themselves from open celebration at witnessing such a thorough dismantling. Republican committee member Sarah Mitchell attempted to come to Hawkins' rescue. Point of order, Mr. Chairman. The gentle lady's questioning seems designed more for grandstanding than substantive oversight. Respectfully, Representative Mitchell, Gonzalez replied without missing a beat. Substantive oversight requires substantive accuracy. If we're going to accuse the Pentagon of regulatory violations, shouldn't we at least know what the regulations actually say? She turned back to face Hawkins directly, her folder still containing what appeared to be dozens more documents. Let's examine your statements about the Defense Production Act authorities, Mr. Chairman. Last week on your podcast, you claimed that DPA Section 303 was being used illegally to circumvent competitive bidding requirements. Could you explain to this committee what DPA Section 303 actually authorizes? Hawkins was now visibly struggling. His chief counsel was sliding papers in front of him with increasing urgency, but every document seemed to confirm rather than contradict Gonzalez's assertions. The confident military expert who had opened the hearing was being systematically exposed as someone who had been making authoritative statements about laws he clearly didn't understand. The Defense Production Act provides broad authorities for national security priorities, Hawkins managed. But his response sounded more like a question than a statement. Again, remarkably imprecise, Gonzalez responded. Section 303 specifically authorizes the president to create incentives for domestic production capacity. It doesn't circumvent competitive bidding at all. In fact, it requires companies receiving DPA funding to compete for the underlying production contracts. You've been telling your constituents that the administration is using emergency powers to avoid competition, but that's the opposite of what the law requires. She held up another document, this one appearing to be a legal brief with multiple highlighted sections. I have here an analysis from the Congressional Research Service dated last month that directly contradicts every major claim you've made about Defense Production Act usage. Would you like me to read their conclusions into the record? The hearing room had descended into barely controlled chaos. Republican members were huddling with their staff, trying to figure out how to respond to what was clearly a prepared and devastating attack. Democratic members were watching in amazement as years of Hawkins' confident assertions were being systematically demolished by someone who had actually done her homework. But perhaps most tellingly, the defense industry witnesses were nodding along with Gonzalez's corrections. These were people who dealt with the regulations she was citing every single day, and they knew she was right about everything she was saying. Their body language was telling the real story about who understood defense procurement law and who had been faking it. Representative James Murphy, another Republican committee member, attempted a different approach. The gentle lady seems more interested in playing attorney than conducting oversight of our military readiness. Congressman Murphy, I am an attorney. Gonzalez replied with a slight smile that somehow managed to be both gracious and devastating. I've spent 15 years practicing federal procurement law. I've argued cases involving the exact regulations Chairman Hawkins has been misrepresenting. When I cite DFARS provisions or FAR sections, it's because I've actually read them, interpreted them in federal court, and applied them to real contracts worth billions of dollars. She stood up slightly, something that rarely happened during committee questioning, commanding even more attention from the packed gallery. The question isn't whether I'm playing attorney, Congressman Murphy. The question is why the chairman of this committee has been making legal claims that wouldn't survive a first-year law school exam. The impact of that statement hit the room like a physical force. Cameras zoomed in on Hawkins' face, capturing an expression that would soon become a meme across social media platforms. His mouth was slightly open, his eyes wide with what appeared to be genuine shock at finding himself so thoroughly outmaneuvered. Furthermore, Gonzalez continued, her voice taking on a tone that suggested she was just getting warmed up. There's a broader issue we need to address about the integrity of this committee's work. Mr. Chairman, how many defense contracts have you personally reviewed in their entirety during your tenure on this committee? The question hung in the air like a live grenade. Everyone in the room understood its implications. Hawkins had built his entire reputation on detailed knowledge of defense procurement. But Gonzalez was asking whether he had ever actually done the basic work required to have that knowledge. I receive regular briefings from committee staff and Pentagon liaisons, Hawkins replied, his voice barely audible through the microphone. That's not what I asked, Mr. Chairman, Gonzalez pressed. Have you personally read complete defense contracts? Have you reviewed the full text of the procurement regulations you cite so confidently? Have you actually studied the federal acquisition regulation that governs every contract you've criticized? The silence that followed was deafening. Hawkins looked to his staff for help, but they were staring at their shoes, unable to provide an answer that wouldn't make the situation worse. The defense industry witnesses were now openly watching the exchange with fascination, having never seen anything like this unfold in a congressional hearing. Because I have, Mr. Chairman, Gonzalez continued, her voice now carrying unmistakable authority. I've read every contract you've criticized. I've studied every regulation you've cited. I've consulted with procurement officers, defense attorneys, and Pentagon officials. And what I've found is that virtually every legal claim you've made about defense procurement has been wrong. She pulled out what appeared to be a summary document, holding it up for the cameras to capture clearly. This is a compilation of 43 specific legal errors you've made in public statements over the past 18 months. 43 times you've cited regulations incorrectly, mischaracterized contract provisions, or invented legal requirements that simply don't exist. The hearing room erupted in gasps and excited whispers. Journalists were frantically updating their editors about what was becoming the biggest congressional story of the year. Republican members looked shell-shocked, while Democrats struggled to maintain professional composure in the face of such a complete demolition. But Gonzalez wasn't finished. She had spent weeks preparing for this moment, and she clearly intended to make it count. Mr. Chairman, she said, her voice cutting through the chaos with surgical precision. There's something else the American people deserve to know about your claims of military expertise. You've positioned yourself as the definitive congressional authority on defense procurement. You've made legal arguments on national television. You've accused Pentagon officials of violating federal law. But there's a fundamental issue we need to address. She paused, ensuring every camera in the room was focused directly on her. You've never practiced procurement law. You've never represented a client in a federal contract dispute. You've never argued a case involving the regulations you cite so confidently. Is that correct? Hawkins' response was barely a whisper. I served as a naval officer years before entering Congress. Yes, Gonzalez acknowledged, and I respect your service. But serving as a junior officer doesn't qualify someone to interpret complex procurement law any more than flying in an airplane qualifies someone to design aircraft engines. She looked directly into the primary camera. The regulations you've been misrepresenting aren't military doctrine, Mr. Chairman. They're federal law. And interpreting federal law requires legal training and experience you simply don't possess. She stood up completely now, something that commanded immediate attention from everyone in the chamber. I've spent my entire career in federal courtrooms where getting procurement law wrong meant my clients could lose billion-dollar contracts. When I cited a regulation, if I got it wrong, companies could go bankrupt. When I quoted a contract provision, if I misread it, thousands of jobs could disappear. Her voice took on an intensity that made the room feel smaller, more focused. But you can make up regulatory requirements. You can misquote federal statutes. You can mislead the American people about defense spending, and until today there have been no consequences. She sat back down and pulled out her phone, holding it so the display was visible to the cameras. Mr. Chairman, are you aware that making false statements to Congress about federal law can constitute a violation of your oath of office? The color drained completely from Hawkins' face. Now, I'm not suggesting you've intentionally misled this committee, Gonzalez continued carefully. But you've made numerous false statements about federal procurement law in official proceedings. You've submitted documents with incorrect legal citations. You've entered testimony into the record that contains fundamental errors about regulations that govern billions in taxpayer spending. She pulled out one final folder, this one noticeably thicker than the others. I'll be submitting a formal request to the House Ethics Committee for review of these matters, along with all the documentation I've presented today. 57 false or misleading statements about procurement law, 23 incorrect regulatory citations, 14 mischaracterized contract provisions, and 6 completely fabricated legal requirements. Republican staffers were now in full crisis mode, with several leaving the room entirely, presumably to coordinate damage control efforts. The defense industry witnesses looked like they were watching a car accident in slow motion, unable to look away from the systematic destruction of someone they had considered an ally. But here's what really matters, Mr. Chairman. Gonzalez continued, her tone softening but losing none of its devastating effectiveness. This isn't about embarrassing you personally. This is about the integrity of congressional oversight. When this committee makes legal arguments about defense spending, the American people should trust that those arguments are based on actual law, not fiction. When we demand accountability from the Pentagon, it should be grounded in real legal violations, not manufactured controversies based on misunderstood regulations. You deserve representatives who tell you the truth about defense spending, even when fiction would be more politically convenient. Today proved that preparation defeats presumption, that expertise matters more than bravado, and that sometimes one person armed with facts can silence years of confident misinformation. If this breakdown inspired you, smash that subscribe button and hit the notification bell for more moments when truth triumphs over political theater.